The Public Safety Committee will come to order. We don't have a quorum as of yet, but given that we have kind of a busy agenda, I think we should just start with our agenda. We'll wait for approval of minutes till we get some more folks here. We have, I think, 8 bills on the agenda. Some are very similar in nature. You will be pleased to know that we have a room scheduled at 4 o'clock, so it's my intent to get us out, at least of our committee, by dinner time, and so we won't have to come back after 6. I don't think it's possible to complete this during our morning session, but we'll give it a go. First on the agenda is House File 2288, Representative Atkins. Representative Atkins, welcome to the committee. The chair will move House File 2288, and you have 2 amendments, I guess. Are they both yours, or are they both yours?
Mr. Chairman, there is one that I submitted that law enforcement was brought to me that I do not intend to offer today, and the other is the A1 amendment, which is an author's amendment. I'm assuming you're at a quorum now, and that's why we're able to move the bill and the author's amendment?
We have a quorum. So, Chair will move House File 2288. The Chair will move. Do you want to explain the A1 amendment? Then I'll move the amendment, and then we'll see if there's any discussion on it. The Chair will move the A1 amendment for the author of the bill.
And thank you, Mr. Chairman. And perhaps what I can do is just give an overview and tuck in the pieces from the amendment as I go, because I think that's probably the best way.
Why don't we just vote on your amendment and get it in the shape that you want it, and then we can... Is there any discussion on the A1 amendment? They're shown? No. Yep. Oh, okay. All those in favor of the amendment signify by saying aye. Aye. Opposed? That motion prevails. Representative Atkins, now the bill is in the shape that you wanted it. Please proceed.
And thank you, Mr. Chairman. When I've described this legislation to people, they are literally shocked that the government can access the location of your cell phone without your knowledge, without a warrant, without probable cause, and without notice to the person that's involved in their investigation. There's just an expectation when you talk to the typical person on the street, and you tell them that, did you know that the government can access the location of your cell phone without your knowledge, without a search warrant, without probable cause? They just expect that the law enforcement, the government would have to go through that to protect a person's privacy, to protect their liberty. That is not the case under current Minnesota law. On behalf of myself and Representative Holberg, Mr. Chairman, we appreciate your hearing the bill. We'd appreciate members' support. I appreciate the adoption of the author's amendment. Law enforcement, the community law enforcement came to me last week on Tuesday, and I appreciated the opportunity to visit with them. I don't think that they will testify that the bill is perfect at this point, but we did do a number of things to try to accommodate some of their concerns that I thought were very practical in nature. Under current law, which was written over 25 years ago now, they didn't imagine these sorts of devices. When they wrote that law the better part of 2 decades ago, they didn't imagine that each one of us, or many of us, 90% of Minnesotans, would be carrying a device like this in their pocket that would tell government where they're located. Other than Representative Mullery, I think everyone in the room probably carries one of these devices around. As you know, current law requires a search warrant for wiretaps. It requires a search warrant for access to your electronic communications. All this is aimed to do is to update Minnesota's law to recognize that these sort of devices have been developed in the meantime. So it says that the same sort of laws that apply to a wiretap are the same sort of laws that apply to access to the contents of an email conversation would be required for access to tell people where you've been when you're traveling around with one of these devices. Why is that important? Because I would imagine that completely innocent people, probably they go to certain churches, they associate with certain groups, they talk to certain people, they're in a variety of locations. that kind of tells a little bit about who you are and what you do and what you believe in and who you associate with. So when we talk about people's privacy, when we talk about their liberty, that's what we're talking about, is the ability for whether or not government should have the ability to figure out where you've been, not just right now, but dating back many, many months. And by the way, Mr. Chair, and I'll sum up here because I've got a testifier, but I do want to recognize Representative Lesch's efforts on the same very issue. I think we're both going down the same path. Representative Lesch prosecutes folks. I was the police officer's legislator of the year last year. I probably won't be this year, would be my guess, but I don't know. Neither one of us is out to get cops with respect to this. What we're out to do is make sure that people have the protections that they expect of their own private information, that they have the expectation of, when you're talking about preserving people's liberty, that you should be able to be free of having government follow you around. So what this law does and what the amendment does is very simply require a search warrant, not just an administrative sort of thing, but an actual search warrant to show that there's probable cause that you've engaged in a crime. Right now, the standard is much lower than that. It just says that it's got to be material to, it's got to be relevant to, related to, of the possibility. It's a much, much lower standard. What we have, based on what the police officers indicated to me last week, what they're concerned about is the notice requirement, which is required for any other sort of search, a wiretap, access to email communications. What they're concerned about is that will jeopardize an ongoing investigation, and I completely agree. We initially had 3 days and 10 days in which to share that information with the person being investigated. You'll see that probably the key feature in here, Mr. Chairman and members, is the extension in several places to a 90-day window, such that law enforcement does not need to notify the person that's being investigated until up to 90 days. They can delay it so that an investigation is not jeopardized. They can also get, with a judge's approval, they can get an unlimited number of additional 90-day extensions if the investigation is continuing to go on. Nobody wants to put a police officer in jeopardy or jeopardize a current investigation, but we do want to protect people's privacy. And folks have an expectation of that dating back a couple hundred years. They should be able to expect that they can travel around this great country and this great state without folks following exactly where they're going and what they're doing and who they're associating with. With that, Mr. Chairman, I do have one testifier, and then look forward to hearing from the police and others who have some concerns.
Mr. Neumeister, welcome to the committee.
Mr. Chairman, members of the committee, my name is Rich Neumeister. If you take a look in your packet, you have some information from myself that provides you an indicator of how the kinds of information that it's done. Basically, there is information about our location in various third parties, cell phone companies, location services, whatever. One of the ways you get it, if you look in my packet, you'll see 3 examples of administrative subpoenas. A lot of the information that I've gotten has gone over a year and a half making data practices requests, trying to get information from law enforcement agencies and what they do. It's been very hard, and I've had to work with them to get certain kinds of information. You have an example of that for Dakota County. It talks about, again, GPS location. You have one from St. Paul, which also talks about GPS location. You have one from the Department of Public Safety, where they have subpoena power within their own agency where they can get location data. Again, it's a very low threshold. It's relevant to an investigation. And basically, it's under 388.23 that the county attorneys issue the subpoenas for law enforcement officers, and various agencies throughout the state have their own administrative power. The second item, you have an example there of a Hennepin County court order. That particular court order is based on law that was done 26 years ago for pen registers, trap and trace devices, and what one calls location devices. Now, these are the language back then was for a location device that you would attach to a car, that a law enforcement officer would attach in a container that follows you, or on you somehow they may do that. It is not done, and it was not, nobody, like Representative Atkins said, nobody had an idea that smartphone that you carry in your pocket, or that app, was going to be doing that. So the court order that you have as an example, in my data gathering, raises issues about as to what is a search. Now, it appears, at least with the court orders that I've seen, there are two kinds of court orders. One is for historical data, but generally they use a combination of administrative subpoenas and court orders, which is a very low threshold, a relevancy type standard. Then, if they want to get it contemporaneously, while you're walking around the legislature here, or your constituents, or not saying anyone's being under investigation, but when folks walk around, they get a court order, and up to 60 days, they can get information. Now, it's not too clear if a stingray is done with this, or a kingfish is done with this, and that's one of the issues that Representative Atkins in the bill and Representative Lesch with his bill is doing, confronting you as legislators to come up with policy to be caught up with the technology. What you also have in your pocket is a retention schedule of all, basically, what the companies, how long they keep the historical data. Also that you have in your pocket is a description, or in your packet is a description of what the kingfish is and what the stingray is. So, Mr. Chairman, members of the committee, I think this is a very important bill, and the legislature is well suited to understand this, because you've seen the changing attitudes of the public in some of the issues over the past year, whether it be the LPR debate on the House floor, whether it be the stingray, the DVS issues. You want to be able to draw boundaries to balance privacy with public safety. And I think that this bill does it. And I'm sure other points and points that you may raise will enunciate some other issues that may need to be addressed. So, Mr. Chairman, members of the committee, I want to thank you very much for the opportunity.
Thank you for your testimony, Mr. Neumeister. Do you have any other witnesses?
Not that I'm aware of, Mr. Chairman.
Are there any questions at this point? Representative Savick.
Thank you, Mr. Chair, and thank you, Joe, for bringing this bill forward. The question I have is, now with cars and OnStar, you know where people are at all times, so does this bill cover cars too, or should it?
Representative.
Mr. Chairman, that is an excellent question. Perhaps with Mr. Diebel's assistance, what it specifically says is electronic, and I want to find the exact section of the bill.
Mr. Diebel, do you have any?
Mr. Chair and members, I think in a business like OnStar would be, because the definition of location information service means the provision of a global positioning service or other mapping, locational or directional information service. And so I think they would fall within that definition.
Okay, thank you.
And Mr. Chairman,
Representative Atkins.
thank you, Mr. Chairman, and Representative, my intention is that it would. The same sorts of location issues arise with that sort of service. I just wanted to make sure we defined it correctly in the bill.
Okay.
Mr. Chair?
Representative Lesch.
I believe Representative Johnson has a bill that goes directly to that question as well, as a separate issue, but I just want to point that out because he's been working on that.
A quick question before we bring up opponents of the bill. I had an amendment drafted, and I violated our own rules, so I'm not going to offer it now, but when it gets to civil law, I may, but because I didn't get it in on time. But I was a little concerned on page 2 of the bill on subdivision 2. So maybe some clarification so I can decide if I need to do it or not. So you're talking only about collecting this data or tracking people who committed a felony. And I'm wondering if there are gross if maybe it's a question for law enforcement, but if there would be appropriate for law enforcement to be tracking the whereabouts of some cases that might rise to the level of gross misdemeanor. I was specifically thinking of domestic violence, stalking kinds of cases where law enforcement may. So are they precluded in your bill from monitoring those individuals because it doesn't rise to a felony level? And I guess that's question number one. And then would you have to follow the same procedures under your bill for if we also included gross misdemeanors or even misdemeanors?
And, Mr. Chairman, thank you for the question. I don't want to offend the chair, but I was kind of relying on you to have that amendment because I do support it. But the fact, I understand that you wanted to comply with your own 24-hour rule. I fully support the point that you're making, and I expect we'll hear the same sort of concern from the law enforcement community. I would welcome an amendment taking into respecting their concerns as well. It may not simply be in the domestic assault world. There may be other situations that they. So when we put in felony, that was to begin the discussion. But I would welcome, perhaps in the Civil Law Committee, which I understand some of the members in here are also on, we could make that change. I'd welcome it.
Very good. Thank you. Is there anyone who wishes to testify? Oh, Representative Newberger, I'm sorry. Oh, Representative John. Oh, we have several questions before we get Representative Newberger first.
Thank you, Mr. Chair. Two brief questions. I just wanted to point of clarification for Representative Atkins. None of this would apply to any federal agency. Is that correct?
Representative Atkins.
Mr. Chairman, and with Mr. Diebel's assistance, I don't believe we have the ability to do that.
Thank you, Mr. Chair. I thought that was the answer you were going to give. I just wanted to make sure that was out there so that members of the public would be aware that this only applies to state and below. Also, a second question then as a follow-up, would state agencies or other local law enforcement agencies, would they be able to do any type of end-around? Would they be able to request from a federal agency data? Would they be able to do that? I guess that's question number one. And then a follow-up to that would be, if so, if that's something that they would be able to do, end around this law, would there be the opportunity to put into this bill an amendment that would require notification that was done?
Representative Atkins.
Mr. Chairman, Representative Newberger, thank you for that. Was not an issue I had thought about. I would suggest perhaps posing the same issue to members of the law enforcement community to find out what their response would be. And to go back to the first question very briefly, I suggest that we should suggest this sort of thing to our federal officials as well. It's happening, I believe, Massachusetts, now New Jersey. Other states are already going down this path of requiring the search warrant be done. But obviously, if you leave a loophole in allowing for an end around, and maybe our folks will say they just simply don't do that. But I look forward to hearing their testimony.
Mr. Diebel, do you have something to add to that question?
Mr. Chair and members, I would interpret the notice provision on page 3, subdivision 4, to address that situation. If a local law enforcement agency were to request that information, even from a federal agency, I believe the notice provision is drafted broadly enough that it would require the agency to inform the subject of the request of their inquiry.
Now, that's excellent drafting, Mr. Chairman.
Representative Johnson.
Well, Mr. Chair, Representative Atkins, again, a couple questions. Probably, other than probably two other people in this room, one of the few people that ever have had to go obtain an administrative subpoena. In the county that I worked in, it was not that easy to get one. The county attorney's office, at least in my county, is very careful on giving them out. There's been a number that have been declined for him. So the administrative subpoena is a very good process to go through, a lot less cumbersome to the court system. But I understand why you want to go with a search warrant. A lot of this data is not owned by the individual that they're getting the information on. It's part of their contract with the phone companies when they obtain the phone. It's an option they have. For me, myself, I turn my GPS off, so mine's not being tracked. But not only do the companies track that as well, we have other private companies that track the phones when they're in their store. We have a number of them that track where you go in their store, what you're looking at, and eventually what you're buying, because they know where you went in that store, what you buy at the checkout. They know exactly what you're purchasing, and if you use your debit card, they even know who you are. How does that information be affected by this bill?
Representative Atkins.
Mr. Chairman, Representative Johnson, in terms of the latter part of your description, in terms of debit card and so, it doesn't. I'll readily admit that it doesn't go that far, but it does. Whether the data is technically owned or not by the person who's carrying this device, perhaps it's owned by Verizon or Sprint or T-Mobile, but when I've talked with, I don't know, dozens of people about this very bill, and there's certainly an expectation of privacy. My guess is if we surveyed everybody here in the room about whether or not where they've been the last 6 months, the churches that they've gone to, the groups they've associated with, the people that they've talked to, and that there's an expectation that there's some privacy there. So I fully, and by the way, I should acknowledge at the outset, I'm not saying it's a walk in the park to get an administrative subpoena. I'm just saying what we did was 25 years ago, nobody anticipated these devices. And so when we talk about it, it's no different than any of the other sorts of things that were expressly talked about 25 years ago. All we're doing is updating it to recognize that we've got a new piece of technology to which that search warrant and probable cause and those sorts of privacy protections that people have ought to apply.
Representative Johnson.
Mr. Chair, Representative Atkins, I agree that the technology was not even thought of at this time, or 25 years ago when this stuff was originally put together. But going back to the administrative subpoenas, getting that information from the phone companies that sell them, a lot of times the information that we do obtain from them is so old that it's just going back to verify information we already have. It can take 60 to 90 days and sometimes longer for them to even respond to it and get you the information. So it's not real-time tracking that there's going on. There is times that there is real-time tracking where we ping the phone, and that is generally in a lost person that we're trying to locate. I've done it myself in a unfortunate suicide situation. That's how we end up finding the person. And there's really tight guidelines on when that can be done. So I understand the purpose of this bill, but I'm not sure if it's 100% needed at this time.
And, Mr. Chair, on that point, we did preserve those protections so that if there's an emergent situation like the ones you described, that's expressly allowed for in this update to the law. Thank you for making that point. I should have made it in my initial comments.
Representative Uglum, Representative Lesch, do you have something? Okay, thank you. Representative Uglum, and then Cornish.
Thank you, Mr. Chair. Well, personal privacy, of course, for everybody is a big issue. I think it's important to balance this with law enforcement's needs. And right now, of course, there is a process where law enforcement does have to go through to get these court orders and things. But my specific question, Representative Atkins, is on page 3, subdivision 3, your time period and extensions. Now, I'm not a peace officer like some people in this room, but you talk about the collection of information for a period if you go through the process not to exceed 60 days, and then there's an extension for 60 days. I guess I'm concerned that that's not going to give law enforcement enough time to do some of their investigations. I do know that some drug enforcement actions take even years. Why are we being so restrictive in this time period extension in this bill?
Yeah. And Mr. Chairman, Representative Uglum, I think we're mixing a couple points. In terms of the extension, and maybe I should have been a little more clear in terms of the amendment, what we allowed under the initial draft, you're right, we only had 10 days in which to share it. This now allows for a 90-day extension, and then we also, on lines 4 point, I guess it would be 410, that it could be with a court's order, it could be extended an additional 90 days in terms of the notice. If you're talking about the 60-day period.
Yeah, on 3.6.
Right. With this, and there's no magic to that, Mr. Chairman and Representative Uglum. If you have a different, if you think it should be only a month, if you think it should be 90 days, but what we're starting is the discussion on this point. I definitely welcome both input from you and from law enforcement in terms of what that period of time ought to be. We're just trying to find what's that snapshot in time. Should it be 5 years worth of records? I don't know that they even maintain that many, but I think the common answer to that would be no. Should it be 1 day or 3 days of records, and then you have to go back and get another order for 1 to 3 days? The answer to that would be no. Somewhere between those two extremes is probably a figure that works.
Can I just add, Representative Uglum, just, you can ask your next question, but both this bill as well as the Lesch bill are going to civil law, and so all the questions that we raise will have an opportunity to make it a better bill. So, Representative Uglum.
That's fine, Mr. Chair. Thank you. I'm just concerned that this is very restrictive.
Very good. Representative Cornish.
Mr. Chair, excuse me for losing my voice.
Yeah,
There's probably a lot of people are glad that I did.
sick.
Representative Atkins, I just have a hard time understanding the impetus for the bill. I can see about the commercial restriction, but even there, I lost my cell phone here back about 3 months ago. I couldn't find it. I just went on the internet, went to find my phone, didn't have to buy an app. All I had to do was put in my number and my name, not even my full name or date of birth. And I got a Google map, and it went right on a dumpster out in the country where I just dumped the garbage. I forgot that I'd had a handful of mail and my cell phone. I threw it all in, and it was already available. And there's a number of applications and high-tech information, I think, that already does this. I don't have any problem with the commercial restriction, but when you get into law enforcement, one thing that's missing in the packet is a list of violations or harm or things that have occurred to bring this about. And I've never really heard of a case yet. And the ones that have been in the news recently that caused a lot of consternation, the judge is even ruling now that you really don't have a guarantee of protection for even your name and date of birth. And so, and throwing some of those lawsuits out. So I don't see, it seems like law enforcement, you already have two levels. First of all, law enforcement in general, I think people still have a trust in that they're going to do it right. And second, though, the administrative subpoena. So I don't have any problem with restricting Target and Best Buy and all these things from certain things that they do, but it just seems like this is a little bit over the top for law enforcement. So just wondering what your comments was.
Representative Atkins.
Mr. Chairman, Representative Cornish, I don't want to stop law enforcement from having this tool. All it says under the current standard for an administrative subpoena is something along the lines of it's got to be relevant to or possibly relevant to an investigation, something along those lines. All this does is apply the same sorts of protections that come along with a search warrant, that there need to be some probable cause that it's relevant to a crime of being committed. So it's that standard that comes along with the search warrant. And no different than what we talked about when the law was initially adopted 26 years ago. For a wiretap for access to electronic communications and the content in there is that you have to meet that standard. And I think that's why you're starting to see this pattern across the country. The Massachusetts court, the New Jersey court, other states are all going down the same path, is just updating their statutes to recognize that we didn't have these devices 25, 26 years ago when many of us adopted those original laws to protect that data. So it still gives law enforcement the ability to get it. There just needs to be probable cause to demonstrate that some crime is being committed. And then requires notice at some point, but not during the course of the active investigation until a judge says so.
Representative Schoen.
Sure, I wasn't.
Oh, you're still doing it?
Just the counterpoint
Cornish.
would be that I worry about the search warrant is quite a high bar. It's a lot different than the administrative subpoena. I just didn't see the need for it. And hopefully law enforcement will testify about the portability of evidence and the quickness of the events can change and the need to act quickly and not have to go through a search warrant at certain times. So that's all I got, Mr. Chair.
Thank you, Representative Cornish. Representative Schoen.
Thank you, Mr. Chair. And I was going to offer the DE1 that was in the packet.
All right. Representative Schoen.
Mr. Chair,
DE1 amendment.
a lot of the conversation that we've had today is talking about probable cause, and I think that's a fair statement. I think times have changed, and I think there's this. We've kind of had this big discussion where we see national news, and we're not happy that the NSA is tracking folks and leaders in other countries. I agree. And it's almost like our own local law enforcement has been villainized just a little bit, trying to do our jobs. I see this as a possible solution to this bill, and Representative Atkins, I really appreciate your tone throughout this conversation, because there's a lot of people around here that have been really using this conversation for political gain, and it's been kind of disheartening. So I'd strike that reason to believe, starting on 1.8 and then into 1.9, just change that in our statute to probable cause. Which may rectify the whole discussion about the search warrants and altogether, if probable cause is the issue.
So what are you doing here? So you're Representative Schoen, you're deleting everything in the bill.
Correct. And changing statute 626A.37 to reflect the need for probable cause rather than reason to believe. And that's the warrant area for the mobile phones.
And Mr. Chairman, whenever you're looking for a response.
Atkins, I am looking for a response. Representative, I have some responses to the amendment myself, but go ahead, Representative Atkins.
And Mr. Chairman, first, it's in the category of no good deed goes unpunished. I actually had this put in the committee's packets because law enforcement brought it to me on Saturday or Sunday. And I knew you had a 10 o'clock rule yesterday, so I wanted to make sure that I got their proposed amendment. I think they're actually a little mixed up in terms of what this amendment does.
Say it again. I can't hear you.
What this amendment would do is actually a distinctly different from what our bill does. As a separate bill, I would actually support this. It recognizes there was a U.S. Supreme Court decision that says if you take one of these devices and you put it on a car, the various things that are applied about this amendment, it says that you do have to have probable cause. But that is separate from cell phone location data. If Representative Schoen wants to indicate in here that it applies to cell phone location data and have the probable cause requirement, then we're probably all on the same page. It becomes kind of a mess to do it that way, and that's why I think the language of our bill is much more clear. But this is on an entirely separate piece of law enforcement's investigatory tools. I think when law enforcement brought it to me, they thought that our point was to get after, when they're planting devices in boxes or on cars or things like that. That's a separate issue. So for that reason, I don't think the delete all would make much sense on this particular bill.
Oh, Mr. Chair,
Representative Schoen.
I appreciate Representative Atkins. His ability to work with people is like no other. I'll withdraw the amendment for now, and I think that this needs to be worked on. We need to touch on this language. I do have a question about search warrants, and maybe Mr. Diebel or Representative Atkins can ask this. Is there any other search warrant that we do right now in law enforcement? I kind of think I have the answer, but I'll look for expert testimony. That we require, when we do the search warrant, that we actually have to provide the suspect with a written notice that it was done.
Mr. Diebel, do you know the answer to that?
In context right now, the search warrants, they get filed, they become public, Once the case is concluded, they become public. And that's all public data that can be made through a request. Do we have to notify anybody directly, or would this be the first in history to do so?
Do you want to take some time? I'm just wondering, Representative Schoen, if you can just hold on your question, if you have others, and Representative Lesch do it, and then Mr. Dibble can...
Yeah, I can hold for the answer, Mr. Chair.
Thank you. Representative Lesch.
Thank you, Mr. Chair. My question actually is more probably for Mr. Neumeister. Mr. Neumeister, and maybe I should know this, but I'm trying to recall, what is the current status of a investigated individual's location data as far as the status of that data? So, for example, if the government was investigating me and they concluded and found out, well, right now we're not charging him, we're investigating him. At the conclusion of that investigation, how much of that data is available? What's its classification? And would that change under the proposed bill?
Mr. Neumeister.
Mr. Chairman, Representative Lesch, the general thing is no, it will not change. I mean, if there's an investigation, it's active, it's confidential. Under 1382, the basic rule of law is that after the investigation is done, and it's an active investigation, it becomes inactive, everything becomes public except those exceptions. And there are numerous exceptions.
Okay. Thank you, Mr. Chair. So if someone wanted to find out, if someone got wind of the fact that I was being investigated 5 years ago, and they wanted to find out where I was hanging out 5 years ago so that they could match it with what they know about where I'm hanging out these days, any person could go and get that information about me currently?
Mr. Neumeister, do you know the answer to that?
Mr. Chairman, members, Representative Lesch, it all depends on what's in the investigation file, in the inactive investigation, and what's in there. I don't know. I mean, it all depends on what's in there.
Thank you, Mr. Chair. And I'd like to get some clarification on that, because my understanding is that they can, that it is public, and this goes toward my appreciation for Representative Atkins bringing forth this bill, too, because the implications for this aren't just toward what law enforcement can do now. The implications are also the fallout from those investigations years later and individuals' privacy rights. So all of you who ran for office, what kinds of youthful indiscretions did you commit back in the day? Okay. Well, for those people who are youth these days and they run for office 20 years from now, what's to stop anyone from going and investigating and find out they hung a little bit around too much at too many bars in college, because we've got those locations from back then. That's the thrust of my question. But the reason I wanted to say something is because of the offer of the delete all amendment. I think that your language, Representative Atkins, is a little more prescriptive and is called for beyond just the simple requirement of a warrant, which I think is also a step in the right direction. So we agree. So that's all I wanted to say, Mr. Chair.
Mr. Diebel, do you have a response to Representative Schoen's question, or do you want to wait? Okay. Okay, I would like to...
Mr. Chair, just if I might, to Representative Schoen's question very briefly, I believe that in wiretap situations, notice is required at some point, and I think perhaps those in the law enforcement community might be able to be of assistance, but that's what we're drawing some analogy to. Though during the active investigation, they obviously don't disclose it. They get a delay until a judge says that they actually have to notify the person whose phone they were tapping.
Okay. We have another bill, Representative Lesch's bill, but I'd like to take testimony now from anyone who opposes House File 2288, or anyone from the audience who wants to speak in favor of it, too. But let's take opponents, and if we could just keep your comments relatively brief, that would be great. And if you could introduce yourself for the record, that would also be good.
Good morning, Mr. Chair and members of the committee. My name is Drew Evans. I'm the Assistant Superintendent at the Bureau of Criminal Apprehension.
Jim Franklin, Executive Director, Minnesota Sheriff's Association.
And good morning. I'm Commander Ken Reed. I'm here representing the Minnesota Chiefs of Police Association.
Welcome, gentlemen. Who wants to start?
I can begin, Mr. Chair.
Okay.
Members of the committee, I would want to clarify right from the beginning that I don't know that the members up here are complete opponents to the bill, and I understand some of the things that you're trying to accomplish with this particular bill and the review that you believe may be necessary for us to obtain this type of information. However, this information and utilization of these technologies is extremely important to Minnesota law enforcement and our charge to help protect the citizens of this state in locating and apprehending violent criminals throughout the state of Minnesota. That being said, we always, whenever we're utilizing a technology, continually are examining privacy implications and our use of the technology, and that we're obtaining any information we may along the way through the means that is legally necessary, that is appropriate, and so that we both can use that information in any subsequent court proceedings, and that we're, again, keeping in mind the interests of our citizens. We've utilized this technology for the past 5 years or so at the Bureau of Criminal Apprehension, and as I noted before, it's primarily used in violent crime investigations or in situations where people's lives are in immediate risk of harm, possibly death at that time. There's some concerns and pragmatic considerations that we'd like the committee to consider when reviewing some of these bills as we go forward. The first that we note that I think some of the concerns have been raised here is, one is the felony level crime that's noted. That would be the only possibility to use this type of technology. There are situations and cases where we're examining people. It could be a stalking case. It could be a domestic abuse case where it's necessary to locate somebody very quickly to mitigate ongoing criminal activity and to ensure that people's lives are not in harm's way at that time. That also, in a felony level crime, the search warrant requirement that's noted here, that would be a narrowing of the historical use of search warrants throughout the state of Minnesota. Search warrants are routinely obtained in the state of Minnesota for misdemeanor, gross misdemeanor crimes in a variety of contexts. So that would be a difference from how search warrants are currently obtained in the state of Minnesota. Some of the considerations that I do have concerns about when it comes to actual search warrants and the term search warrant, and just to help the committee understand, 626A, which is where these bills codify some of these requirements, is the pen, register, trap, trace, and mobile tracking device statute. The search warrant statute is under 626, and there are some considerations with the search warrant statute that make this practically a little bit difficult. Some of the notice and the delay and notification requirements could be in conflict with some of these search warrant requirements. For example, the delay in the notification is done in one manner under this statute. However, in the search warrant statute, or not in the search warrant statute, but in the rules of criminal procedure, under Rule 33, there is a mechanism in place for prosecutors to seal search warrants, and that can be done for an additional time. And I'd be concerned that there'd be conflict between the statute and the Minnesota Rules of Criminal Procedure and how they're currently done. There's also some provisions that we've examined, and it was referenced up here earlier, concerning the search warrant and the notification requirements that go along with those. Now, the question about notification, search warrant notification may not be the term that's used, but people are notified when a search warrant is executed by an inventory and return that's left with the person or place where the item was to be searched. In addition, there's some other considerations. You referenced a court case, which is U.S. v. Jones, which it references the mobile tracking devices, and that probable cause is now required as a federal standard in those cases. I'll tell you from the search warrants and the modifications that we needed to make to comply with that court decision, there are some difficulties with our current search warrant statute in implementing a prospective, ongoing search, which this is, as opposed to a fixed point in time when we're searching a house from there. There's some considerations in there about jurisdiction. We have judicial districts in the state of Minnesota where you can issue that, where it applies, where it can be installed, et cetera, that I'd have a few concerns about as well. I do want to clarify for this committee and some of the comments that were made before. An administrative subpoena cannot be used to obtain prospective, ongoing location information on a phone. The companies don't take it. It is not the legal standard that's done. And in addition, location information is not obtained through an administrative subpoena. We can receive call information that there's incoming and outgoing dial digits. That's historical information that occurred in the past, but we do not get location information. We get location information through a search warrant if it's historical, and what we're currently utilizing is the court orders and the 626A statute that we obtain in order to get that prospective location information on those phones at this time. In reference to the 626A definition of a mobile tracking device, I completely agree that it was not contemplated 24 years ago, last time the statute was updated, that we would be tracking cellular phones. However, if you look at the definition, I think it was actually written fairly well for what the definition of a mobile tracking device is, that it's an electronic device that is used to track the movements of a person or things. And I think that's really what a cell phone has become for us, that we are tracking a particular device relevant to an ongoing criminal investigation as we do that. The notice requirement, I think you've had some of those considerations. I would be concerned if we don't have the proper delay in notification that it could jeopardize current and ongoing criminal investigations along the way. And the reporting requirements, potentially, I'm not opposed, and we're not opposed, I think, as a group, to reporting requirements, but we'd prefer that it's in some sort of summary fashion so we're not alerting criminals that are in our state of the methods in which we're using this technology on a specific basis that would allow them to defeat the technology. And I believe those are my comments.
Mr. Franklin, welcome to the committee.
Mr. Chairman, members of the committee, in the interest of time, Drew has done an excellent job in summarizing all of the points that I would be making. I would just simply add our support to what he has already said. And again, we think that the definition of the mobile tracking device literally does cover all of those devices. We are currently using that basic probable cause standard currently. That is why we brought that to Representative Atkins and suggested that this is a fix that we think is doable within the state and meets the criteria that you're looking for that we can currently live with. All the other issues have been addressed, and I won't be redundant.
Mr. Commander Reed, welcome to the committee.
Mr. Chair, members of the committee, thank you. I also have to agree that Drew did a wonderful job laying out the issues related to this particular language in this bill, the issues about court orders versus search warrants, and both are based on probable cause, both are subject to judicial review. Either should suffice in this situation. Limiting the felony crimes, Mr. Chair referenced that already. Stalking as a gross misdemeanor crime would be precluded under this language. That makes no sense, and neither does domestic abuse under misdemeanor or gross misdemeanor. So we're looking at dealing with that issue. That sounds it. The big concern that the chiefs have is that any premature disclosure of information, whether the means, the method, or the information itself, mid-investigation, especially when we're dealing with long-term criminal investigations or organized criminal groups, is going to be an issue in terms of loss of future additional evidence, and also we believe an officer safety, investigator safety issue. And that's our big concern about this, is that any premature disclosure. The subject of an investigation using these methods, we believe that disclosure should wait for the discovery thing if that person is charged. If that person is not charged, I think there's some other comparable statutes. Financial records, Chapter 13A comes to mind for someone who's not, or someone who was exonerated in an investigation. That would be a more amenable time frame for notification. So other than that, I think that everything else was covered here, Mr. Chair. Thank you.
Any questions? Representative Lesch.
Thank you, Mr. Chair. And just by way of clarification, in light of some of the other questions that have been asked, Mr. Evans, can you tell me if I turn off location tracking on my phone, if I turned off GPS, can you still, using the pen register enabling language, determine a location for my phone?
Mr. Evans.
Mr. Chair, Representative Lesch, yes, we would be able to, with the proper court order, obtain that information is from your phone.
Okay, thank you, Mr. Chair.
Representative Lesch.
And last, just by way of comment, Mr. Chair, I think, in conversations with Representative Holberg on this issue, and after the conversation we had with Sheriff Stanek out at his patrol headquarters, and also based on the testimony here to it, we're not necessarily as far apart on this issue, I think. It's law enforcement's expectation that there would be a judicial review before this kind of thing happens, and it's not as pervasive as a dragnet or concern about prospective future crime that an individual could potentially commit. So I think comity is achievable on this bill, but Representative Atkins, I like the language that you put forward coming forth, and I'm sure we'll come to resolution on this before it hits the floor. But thank you for your testimony.
Representative Mullery.
Thank you, Mr. Chair. A couple different areas. First of all, I was trying to follow, is this data then after a certain period open to the public? It sounded like that after the investigation's over.
Mr. Evans.
Mr. Chair, Representative Mullery, the information, again, is collected in relation to a criminal investigation. So it would be classified under 1382 and the classification. So it's confidential, protected, non-public while the investigation is active, and then it would be public information once the investigation is inactive.
Well, Mr. Chair and members, I'm not so worried about law enforcement in Minnesota. I don't really care what they have on me. I really think this is the problem. Why should the public have this information? That seems to me that's our problem, that we don't correct that part of it. My second point is I wondered on the whole implication of the felony. I have probably the most violent crime of any district in the state, so I'm extremely worried about this having any effect that would increase the crime. And part of that is related to the issue of drug sales, many of which I believe are not felonies in the actual individual sale. So how does this, would this in any way affect trying to track what's happening? Because they've become, I've gone and parked a block away from where I know, I'm told the police say there's stuff going on, and watched, and they're very careful about running everything all over the place, different people running to the different locations just in one drug deal. So probably they're keeping it under the felony level, I'm guessing. Would this in any way affect how that, and I guess we have one person here who's actually done some of that undercover work, but is there anything that this would hinder law enforcement on the kind of crime that's going on in my district? Because everybody in my district will be up in arms if you're harming that enforcement.
Who wants to answer that, or is it Mr. Evans?
Mr. Chair, Representative, that is the reason we raise concerns about the felony provision in this bill, that we wouldn't want to limit ourselves. There's a number of situations where we would potentially be asking for a court order for a lesser crime than a felony. And again, as I've noted before, and important to note, we're often using this in terms of violent crime, and that we're trying to mitigate and prevent future criminal activity or ongoing criminal activity. So this tool is being used to apprehend and locate these people as quickly as possible.
And Mr. Chair, that's exactly my concern. We have an enormous amount of violent crime, and a lot of it is related to drugs in some way. So if that's going to have anything, I'm totally opposed to anything that's going to increase our crime.
Representative? Commander Reed, you make it brief. We're going to try
Yes,
to
sir.
get Representative Lesch's bill in here.
Sure. I just want to add that the notification requirements as well can be problematic in the situation that Representative Mullery is talking about, because commonly a search warrant might be executed or a court order executed, which gathers some information, and you analyze that against what's known and not known, and it may lead you to additional search warrants or court orders. And if that premature disclosure takes place before you're able to take that next step, you lose the opportunity to gain evidence or to identify additional suspects. So that's where that disclosure notification thing has to be very carefully thought through. Thank you.
Representative Simon.
Thanks. We're all trying to strike the right balance here. So in view of that, I have a question that I'm not even sure if it's for Mr. Reed, Mr. Franklin, Mr. Evans, the author, or Mr. Diebel. But the question is, where are we in Minnesota on the continuum of ease and convenience for law enforcement getting this information? Are we right in the middle? Are we easier than most states? Are we harder than most states right now?
Mr. Evans.
Mr. Chair, Representative, our statute actually, the 626A is fairly similar to the federal statute in regards to the laws governing this type of information. Now, the court cases, as noted, regarding the standard of review, whether it's relevant to an ongoing criminal investigation or a probable cause standard is the appropriate, is currently being examined and debated in many courts and jurisdictions throughout the United States. So I would say it'd be unfair to put us on a continuum, but there's many adequate protections in place already under our current existing statute, even many that deal with these notification requirements.
Okay. Very good. Representative Simon.
I just have one other follow-up, too, and again, this is an open-ended question that would certainly help me. And Representative Atkins, if you mentioned this, I came in during your opening testimony, so I don't know. Is there a possibility that the courts are going to beat us to the punch on this? I mean, are there cases right now moving their way, upwards to the U.S. Supreme Court that might actually decide this issue? Does anyone know?
Not that we're aware of.
Okay. Wait, Mr. Evans, no one knows. Representative Lesch, do you know?
Well, I bet there are other legal experts in the room who could tell, but U.S. v. Jones in 2012, Mr. Chair, dealt specifically with entry upon a vehicle in order to attach a mobile surveillance to find out where someone's been. So it wasn't necessarily on point for this, but there was plenty of dicta, both in the majority opinion and in the concurring opinion, suggesting that ongoing surveillance of a larger scale may have implications for individual civil liberties. So I expect the court will be there relatively soon, and I expect it will restrict the use that law enforcement currently expects they can use it unfettered for.
Okay. Representative Simon. We have one member from the public that wishes to address the committee, and then we're going to vote on the bill, and the motion will be to refer it to the Civil Law Committee, where I'm hoping that these issues can be worked out. Yes, sir. Welcome to the committee. Please state your name.
Greetings. Thank you. Chair Paymer, members of the committee, my name is Thomas Evanstad, and I'm running for governor of Minnesota, and I have very different experience than what you're hearing from law enforcement here, and I'd like to share it with the committee. I grew up in Edina, Minnesota, 6005 Leslie Lane, about as safe as you can be, believed in the police, thought they were there to protect and serve me. Had a good relationship with the police coming up in Edina, liked the police. Then fast forward a little ways, and then I was 30 years old, living out in Mound. I was falsely accused of a rape. In our statutes, you don't need any evidence, and the person is called a victim in the statute. You're not an accuser, and you're not an alleged victim. You're a victim. So anyhow, how this relates to me is I'm under surveillance. The police are watching me, and how do they do that is through this. And how do I know that? Well, I know that because I've been meeting my dad at White Castle for 5 years, right? And then in the last month or so, since I've been pretty active on Twitter talking about I'm running for governor, which the public and the media won't talk about to you, that I'm publicly talking about dismantling and destroying this police state that we live in, that I've had people coming up to me at White Castle, 2 different African Americans. And by the way, I would note this. Look around the room. There are 21 people here in this committee. And do you know how many African Americans are on this committee? Goose egg. This does not represent the state. This is government of the rich, by the rich, and for the rich. And since I've come out talking about my platform and about how Bob Marley was about social justice, I'll tell you what's happened to me because of this and because of your cops back here. My dad is 86 years old. We like to go have a cup of coffee at White Castle. That's the American way, right? I should be able to go have a cup of coffee at White Castle without the government involved in my dad and my lunch. And in the last 30 days, I've had one African-American plant from the police come up to me and start engaging me with my 86-year-old dad at White Castle, talking about he's seen my marijuana tour operation in Denver, which is if anybody wants to get some medicine in this state, give me a call.
Mr. Evanston, could you wrap up your testimony, please?
Yes.
We have a lot of bills today.
Yes, I will. Here's
Thank
the
you very
problem.
much.
Thank you, Chair Paymer. This is the problem, and it's not even this isn't the problem. Law enforcement is the problem. So I'm willing to comment to people out in the hallway or, give you my information. You can reach me as far as what is my story and what do I have, what is my problem with the police. My problem with the police is that they frame me into prison. And now for what we're talking about today, here's the problem. 2 different people came up to me, like I said, and tried to either sell drugs to me or have me purchase drugs from them. This was not random. They're following me on this. And how they do that is you have one suspect in an area, the police are looking for the cocaine dealer, right? Well, you just happen to live within 10 miles of that cocaine dealer or whatever these insane grabs that they're doing. This is violating our civil liberties. Edward Snowden came forward and he did something courageous, which was to tell us what they're doing at the government. And the founders of this country, Thomas Paine, Nathan Hale, every single American that has died in this country, every veteran, what they would ask you to look at is our civil liberties. They've gotten away from us. You have too much power with the police. And you know what? If we could trust the police, that would be fine. But when they haven't even solved the rape kits, then you tell law enforcement this message from Tom Evanstad. Stay away from the medical marijuana. Stay away from the recreational marijuana. Don't put yourself as a human shield in between these kids and medicine until you solve the rape kits that we have about 10,000 in this state that the BCA won't even tell me how many that they haven't even tested. Okay, and thank you very kindly.
Thank you for coming down, Mr. Evanston, for your
Thank you very
testimony.
much. Yeah.
Representative Atkins, you got the closing comments here. I appreciate that you're bringing the bill forward. I know you're going to work with law enforcement to try to work some of the bugs out, but you have the closing statement.
You said it, Mr. Chairman, in light of the time, and I appreciate this hearing has been terrifically helpful to hear from both sides. We're going to do our best to try to accommodate and find that balance that many people have referenced. So I appreciate the opportunity for the hearing. I appreciate your attention, and I look forward to working with both sides to figure out something that balances privacy protections and liberty against law enforcement's need to do an appropriate investigation. Thank you.
Thank you. Then the chair would recommend that House File 2288 as amended, be re-referred to the Civil Law Committee. Any discussion? All those in favor signify by saying aye. Aye. Opposed? No. That motion prevails. Thank you,
Mr. Chairman,
Representative. Representative Lesch. Representative Lesch, we have about 20 minutes, if that's enough time. You can get it done. Oh, before we do that, I'd like to, are they still here? Where are they from? Are the 9th and 12th graders from Wings Home School? Where is that? Are they still here? Where is that? Where's Wings Home School? Eden Prairie. Oh, so welcome to the Public Safety Committee. I hope you're finding this interesting. It is interesting, isn't it? Okay. And we need approval of the minutes of March 6th.
So moved, Mr. Chair.
Representative Rosenthal makes that motion. Any discussion? All those in favor say aye. Aye. Opposed? That motion prevails. Representative Lesch.
Thank you, Mr. Chair. John Lesch, State Representative of St. Paul, Bob Marley fan. And I have here with me, in fact, better than to go into it, I will just say briefly, Mr. Chair, that I appreciate the last testifiers on Representative Atkins' bill. And like I said, I don't think we're too far apart in achieving the expectation of the state's policymakers with the state's law enforcement community on what's needed in terms of securing a search warrant for electronic device location information. I would also add, I expect that 2 years from now, there's going to be another change, and we're going to be back here because of the rapid pace at which technological surveillance is outpacing our ability to enact reasonable policy for it. But that said, we're working together on this right now. I have with me Mr. Samuelson and Mr. Feist from the ACLU to explain the bill.
Who wants to go first? Mr. Samuelson, welcome to the committee.
Thank you, Mr. Chairman. The ACLU of Minnesota is a nonpartisan, nonprofit organization dedicated to protecting the civil liberties of all Minnesotans under the U.S. and Minnesota constitutions. We have 8,500 members throughout Minnesota and promote our mission through litigation, public education, and lobbying efforts. The ACLU of Minnesota strongly supports House File 2553. This bill updates Minnesota privacy laws to reflect the modern mobile world by providing needed protection against warrantless government access to a person's cell phone location information. Today, more than ever, Minnesotans are both aware of the powerful new surveillance technologies available to law enforcement agencies and concerned about how these technologies are being used. Just last month, the Star Tribune conducted a poll that found that 63% of those surveyed were somewhat or very concerned about the amount of personal information that the state of Minnesota and law enforcement collects on individuals. Most Minnesotans now own and carry cell phones. With assistance from cell phone carriers or through its own cellular tracking devices, the government has the technical capability to track any cell phone owner 24 hours a day for as long as it likes. Cell phones can be tracked in real time, and all cell phone companies keep historical records on where cell phones have been in the past, going back months or even years. Such extensive and precise monitoring permits government agents to construct an incredibly detailed portrait of an individual's life, associations, and activities far beyond what would ordinarily be possible through mere observation. Law enforcement is increasingly taking advantage of Minnesota's privacy laws, written before these technologies even existed, to access sensitive location information without adequate judicial oversight. To be clear, the ACLU of Minnesota is not opposed to the use of new surveillance technologies, such as cell phone tracking in policing. The work of our law enforcement agents is important, and we all have an interest in it being done effectively. However, we believe that safety should not come at the expense of civil liberties. House File 2553 safeguards privacy rights and makes necessary updates to Minnesota law to protect sensitive location information consistent with our Fourth Amendment constitutional rights and values. Most importantly, House File 2553 requires a government entity to obtain a search warrant based on probable cause before obtaining the location information of a cell phone or other electronic devices. House File 2553 balances an individual's privacy rights with law enforcement's need to act quickly in emergency situations by including a number of reasonable exceptions to the warrant requirement. These exceptions include situations when an electronic device is reported lost or stolen by its owner when needed in order to respond to a user's call for emergency services, when the owner or user is believed to be deceased or reported missing and cannot be contacted, or when an emergency involving immediate danger of death or serious physical injury to any person requires obtaining information relating to the emergency without delay. House File 2553 further provides necessary transparency and oversight regarding government access to location information by instituting reporting requirements and requiring that notice be given to the owner or user of a cell phone or other electronic device whose information was obtained. 2 states, Maine and Montana, have already enacted laws to address location tracking, and at least 4 others, including Utah, New Hampshire, South Carolina, and Maryland, have similar legislation pending. We believe that in Minnesota, with balanced legislation, we can preserve the legitimate uses of this tool for law enforcement without sacrificing our core right to be free from unreasonable government scrutiny. Accordingly, we respectively urge this committee to support House File 2553.
Thank you for your testimony. Are there any questions? Would you like to also testify?
Mr. Chair, members of the committee, my name is Benjamin Feist. I'm Legislative Director for the ACLU of Minnesota. I'm just going to quickly point out some of the differences between this bill and the Atkins bill that we just heard. They are very similar in nature and what they're covering. One difference that I would like to point out is that this bill includes, under the emergency involving immediate danger of death or serious physical injury exception, a requirement that law enforcement, when they're using that exception to not have to get the warrant, do still need to go to the court with a signed sworn statement within 48 hours, just so that there's some check on that process. We also differ in the reporting requirements that is part of this bill. In the Atkins bill, there's a reporting requirement on the telecom industry to make clear to the states exactly how many warrants are being issued and the general nature of those. In this bill, we do put that on court administration to take care of and to report back.
Any questions of Mr. Feist? Okay, thank you for your testimony. Mr. Evans, did you want to speak to this bill? If you could just let him. Welcome back to the committee.
Thank you, Mr. Chair. Again, I'm Drew Evans, the Assistant Superintendent for the Bureau of Criminal Apprehension. I don't have much more to add. You know, substantively, I think you see these bills are very similar in their nature and scope, and so I just reiterate some of the same concerns that we reiterated before on the previous bill, and we don't need to rehash the same points.
Thank you, Mr. Evans. Is there anybody in the audience that wishes to speak in favor or in opposition to the bill? Mr. Neumeister, welcome back to the committee.
Mr. Chairman, for the record, my name is Rich Neumeister. I support this bill also. One aspect that I didn't hear the ACLU representative, Mr. Feist, say, another part of this bill, which I think is a good part of this bill, is on the last page. Basically, it says that evidence derived from what they gathered, which is very similar to other parts of our statute in 626A, cannot be disclosed in hearing or whatever. In other words, if they don't follow the rules, you can't use the evidence. The other thing about this bill and both bills that was not mentioned is the technology. The technology is changing fast. And one of the things that we did not even talk about is how tower dumps are being done, where through how law enforcement gets thousands of bits of data, transmissions, it could be location data or whatever, in tower dumps of innocent people when they're looking for the bad person. What happens to all that data? Should that be done with a search warrant or low threshold court order? So that's some of the issues that are underneath here, and in an hour and a little bit of time, it's kind of hard. But I'd be more than happy to share with any of the information with a lot of you. And I just share this one main point. I worked with Tom Pugh, who was very active on this issue, and other people on this issue 25 years ago. And in Minnesota, we did set a little bit more higher standards. And one of those higher standards was the location tracking device, the one that goes onto a car or in a container. And there were other kinds of things. Also the reporting mechanism of pen registers and trap and trace devices. Again, technology changes. So one of the things before I drop dead, which can be who knows when, there have been 4 or 5 things that I've wanted to see changed. One is to update our laws about electronic privacy and communication. And I'm glad that you, as the body that has to do this, are starting to discuss those things. Those are important things, other than just cell phone location. But what about documents that are in the cloud, which only take a very low threshold? So, Mr. Chairman, I thank you for the time on this very important matter, that you all are willing to listen to these bills.
Thank you. Anyone else wish to speak in favor or in opposition of the bill?
Hello. My name is Eric Bauer. I'm a student at the University of Minnesota. I'd like to thank Representative Lesch for authoring this bill and thank the committee chair for hearing it. I support this bill as a necessary protection against possible abuse or misuse of law enforcement tools and as a set of safeguards and protections to that effect. I feel that I've grown up in a society consumed with paranoia about crime and terrorism. This culture of fear, the urgency with which some people feel, and the recklessness also that some people sometimes feel is necessary to guarantee their security, poses an active threat to the rights and privacy of people. This bill makes assertions of the right to privacy that I think are very important, and also takes strides to protect the personal privacy and other rights. I agree with the testimony of Samuelson and Feist of the ACLU, and I support this bill as an advancement of the rights guaranteed in the U.S. Constitution as amended.
Thank you, Mr. Bauer, for your testimony. Anybody else want to address the committee? Therefore, Representative Lesch, are there any questions of Representative Lesch?
Thank you, Mr. Chair. As noted, this is just a small piece that we're trying to do in order to affect what those individuals have stated, individuals who have concerns over government surveillance. But there are multiple other areas that haven't been addressed. For example, Mr. Neumeister's concern over tower dumps. We have an obligation to be concerned with not just the individuals who are being tracked over whom we have probable cause or reasonable suspicion, but all the individual innocent citizens and individuals in Minnesota whose information and data is being tracked over which we have no reasonable suspicion or probable cause, which is a separate issue, also which is addressed in the license plate reader bill that was passed overwhelmingly by the House last session and for which we expect action soon in the Senate. With that, I would ask for your support.
Representative Cornish.
Mr. Chair, just a procedural question here. First of all, are all these bills going to be hopefully a fiscal note requested, because there's a lot of reporting requirements, and I notice this one here affects the judiciary, and so I was wondering what the path, if they're going through like ours and judiciary and wherever they would have to go through to look at these high costs that could be ensued for all this reporting. Like on this one, I see reporting requirements. State court administrator transmit to the legislature a full and complete record concerning the number of applications, yada, yada, and on and on. And so just a procedural fiscal notes are going to be requested.
Mr. Chair.
Mr. Waltz.
Mr. Chair, Representative Cornish, no fiscal note requests have been put in on any of these bills. I had a conversation with the Department of Public Safety to see if they wanted to put in any kind of cost for being precluded from using certain tools, and the response was no. There was one bill, I believe it's this one, that had a requirement upon the courts to report, and I spoke with Ms. Marshall at the courts, and she said it would be a burden, but not one that they would put in a fiscal note request for.
Representative Cornish, the bill is going to civil law, where I suspect Representative Atkins and Representative Lesch will work with law enforcement to hammer out some of the issues that have been raised in this committee, and I don't know if they go anywhere else after that to the floor, I would imagine, or they're going to be part of your omnibus bill, Representative Lesch, or what's your...
Mr. Chair, I don't know yet.
There, you have a succinct answer right there. Okay. With that, do you want to renew your motion?
I will, Mr. Chair. Has to be sent to civil law.
Any discussion? All those in favor of the motion signify by saying aye. Aye. Opposed? That motion prevails. I didn't say no. All those opposed?
No.
That motion prevails. Sorry. Representative Lesch, you have one more bill, and then we'll see if we can get through this, and then we'll take on the drone issue this afternoon.
Thank you, Mr. Chair. I would move that House File, are we doing 2940, Mr. Chair?
2940.
I would ask that House File 2940 be re-referred to civil law.
So Representative Lesch moves House File 2940. You want to introduce the bill?
I'm sorry, Mr. Chair?
I was just saying you moved the bill.
Thank you. Mr. Chair, House File 2940 is the result, the fruit of the informational hearing we held in the last week of January on information regarding electronic surveillance devices used by various state agencies. And quite frankly, Mr. Chair, information was not adequately forthcoming from most of the policymakers who were invited to explain how they use the devices, the technology, and the results of that in a public hearing, which is how we make decisions around here. However, the Department of Public Safety, agency of the state of Minnesota, did appear and show up, and they were forthcoming about how they used that. They, in my opinion, stated reasonable parameters for its use. There remain ongoing questions which are reflected in changes proposed by the other bills that you've heard today and will continue to hear. That said, in my opinion, the responsible agency through which these requests should pass is the Department of Public Safety. And if other local agencies are not interested in stating how they're using the information, I personally am satisfied with the Department of Public Safety signing off on their requests to ensure that they're following the expectations of this policymaking body, Mr. Chair. With that, I would stand for questions.
Questions? Representative Cornish.
Representative Lesch, this is probably the most egregious bills of you have today. I immediately, when I got up this morning, started getting texts from my local sheriff and with all sorts of lively comments, but they didn't like it one bit, and they were wondering the wisdom of trusting or going above a state agency rather than a local decision that it seemed like you'd have more confidence in. And but anyway, it's quite controversial, and they didn't like the idea of having to do this, and I'm trying to see the wisdom in it, too, of going to a state agency rather than trust your local officials.
Representative Lesch.
Mr. Chair, Representative Cornish, is your sheriff here today to testify?
No.
Representative Cornish.
Excuse me, Mr. Chair. I think with the short notice we've been giving here in the committee notices that I don't think they have time to drive up. But I did hear from Blue Earth County and Nicollet County, and I think the Sheriff's Association isn't too happy with the bill either.
Okay. Well, Mr. Chair, the hearing in January invited policymakers for these bills to testify on how they use this technology and its effects, and obviously the benefits they see derived from that as well. But this committee cannot make decisions based on rumor and innuendo or hearsay, and that's why the sheriff of Olmsted County came up and testified about his opinion and how they use it in Olmsted County, and the Department of Public Safety came up, and a couple others. But this committee is not in a position to make good law based upon on hearsay, and I appreciate Representative Cornish's statement that he heard from his sheriffs on this, that they don't like it. But this committee is a fact-finding committee, and it's set up to ask questions of these policymakers and local law enforcement officials as to why. I mean, why don't you like it? What do you like about your technology? What kinds of technologies are you using? How have you used it to combat crime? And then reasonable cross-examination questions about that, like, well, do you really need to go that far? Do you think that some of these individuals were entitled to constitutional protections? If the answer is no, then the questions are ongoing. So that's how we make law around here, and that's I would expect. I don't know if there are any other sheriffs in the audience or policymakers who want to testify on it, or police chiefs, Mr. Chair, but if not, well, I would ask for your support, and maybe they'll show up at the next hearing.
Mr. Chair.
Cornish.
In the GOP packet, at least, we have a copy of a letter from Sheriff Stanek that seems to contradict what you're saying as far as being open and forthright and inviting you over for a complete examination, or at least a look into what they were doing. And it's just the venue that you put up, I think he objected to. And he would rather tell you about it in person rather than go over in committee, especially when it has to do with criminal matters and an investigation. And so he gives a completely different look at it, as you did, about making himself available. He claims that he and other people made themselves available for an actual visit over and look at the technology. So in his defense, I would just offer that. And I think the Sheriff's Association's taken a stand against this bill. So,
Well, Mr. Chair?
Representative Lesch.
Sheriff Stanek did invite select legislators to a meeting to view his use of specifically his cell phone exploitation technology. He did not want to talk about any other technology. He made clear at the meeting that he only wanted to talk about this specific device that he uses, which I certainly appreciated. However, this committee cannot make, as I stated, decisions based on rumor, innuendo, or secret discussions. The entire point of open government, and I think it's somewhat ironic that a law enforcement official would say, well, just between you and me, this is what we do, related to a policy area that is directly on point to secret surveillance. That's why we have an open committee hearing, because government can't be making secret decisions and holding secret information and secret technology based on what citizens do. It's just a matter of basic public policy. So it's true that Sheriff Stanek did go above and beyond in inviting individuals to that, but I don't think this committee can make decisions based on that. Hence, the invitation to have policymakers show up here and answer questions about it.
Representative Uglum, you have a question.
Yes, thank you, Mr. Chair. It is along the same lines. Of course, I represent Hennepin County and Sheriff Stanek. I've had conversations about this bill. When we talk about policy and things, Representative Lesch, I think it's very important that everybody come to the table and discuss this. And obviously, there's some real strong feelings among the Sheriff's Association and local chiefs of police. I would hate to vote for a bill that hasn't been thoroughly vetted. It's an ugly process sometimes. It's tough sitting there and talking to people that you maybe at this point in time feel that they're not doing their share. They feel you're not doing your share. Why can't we wait on this bill, and why can't you get together with these people?
Mr. Chair?
Representative Lesch.
I have no objection to getting together with anyone. I responded to the invitation of Sheriff Stanek, and I don't know what you've heard, but you had suggestions in your statements about me being unwilling to meet, and I think Representative Cornish stated allegations in the letter as well. I have never rejected an opportunity to meet and discuss about this, not a single occasion. Aside from that point, though, as I stated, we can't make policy without the adequate facts. And if you hate for a bill to proceed forward based on inadequate information, well, that was the point of having a hearing in January. And it's not the point of this bill, but certainly I would entertain discussions on this bill, but not a single person has either come to talk to me or make an appointment to meet with me from law enforcement specifically on this bill. So if there's an unwillingness to participate, it's certainly not on my part. Now, Mr. Chair, I would also add this, that I have had conversations with members of law enforcement about the possibility of, for lack of a better term, secret hearings on this issue, similar to what they do in Washington, D.C. with the intelligence community and the FISA courts. It is not my preference. I think that's not the direction we want to go as a republic, having secret hearings to talk about technology that's going to implicate citizens. I think citizens have a right to hear about this information in an open setting. But in the interest of alleviating nervousness on the part of law enforcement about what's going to be said, I am open to talk about it. But again, law enforcement has not talked to me about this bill.
Representative Uglum.
Thank you, Mr. Chair. Well, Representative Lesch, you're a smart guy and a good legislator. And I think that I applaud the fact that you want to, at least it seems like you would entertain the idea to get together and talk to the concerned parties involved. It's not good policy, it's not good legislation when things aren't thoroughly vetted. And so I would certainly hope that you could find the time and everybody could come together and work on this bill, because I think it does need some work. So appreciate it. Thank you, Mr. Chair, but this is not the right way to go about things.
Representative Johnson.
Mr. Chair, Representative Lesch, I too have been contacted by a few people in the law enforcement community, notably a couple of sheriffs in my community, in my area of the state. They have a lot of concerns with it. One thing that they're concerned with is giving BCA full control of all this technology. In what their concern is they would have no control of how it would even be used if BCA was using it in their area. One thing with the sheriffs, they're an elected official in their community. They're going to do things that is the best for their community and what works best for their community, and they are accountable to their community. BCA is not. They're not accountable. With everything going down to BCA being in control of everything, the people in the counties are no longer in control of what their sheriff does, what law enforcement does. And that, to me, that is very concerning. And if we start with this, giving BCA control of everything, what's next? Do we become a police state?
Representative Cornish, then I'd really like to take some more testimony on this and see if we can vote on this bill before we recess. Representative Cornish.
Chair, I'd just like a roll call vote on this one.
Representative Cornish has asked for a roll call. Is there anyone who wishes to speak for or against the bill from the audience? Mr. Neumeister.
Mr. Chairman, for the record, my name is Rich Neumeister. I think the idea and the intent of this bill is a good one. Mr. Chairman, members of the committee, I have taken months and months of interaction with BCA and a great number of law enforcement agencies to try and find out the kinds of devices that they have used public money for to do surveillance on people. It's like pulling teeth. It took me months for a number of variations, and I've publicly wrote about it, I've been interviewed about it, and talked about it in the media. So I think one of the things that's what's the issue here is that, for example, if we're talking about the kingfish, the stingray, the harpoon, the many kinds of things that law enforcement agencies are starting to buy, either through Homeland Security monies or because the technology is becoming cheaper, they don't want to tell you. Because what they're doing, they're signing non-disclosure agreements with companies, which I have a copy of, that Hennepin County has, and maybe other public entities have, that they can't talk about the results. They can't talk about anything, which is contrary to what data practice is all about. And the second item, now, and this is where I differ a little bit, because you were talking about an agency, the Bureau of Criminal Apprehension. Now, granted, they need to become forward and honest with what they're doing with their devices. They spent $600,000 per data request that I've gotten of public money over the last 8 years. And I get nothing from them. From Hennepin County, I got a contract, and I got their non-disclosure agreement, but from the BCA, nothing. And I can point out other agencies that are just stonewalling. Now, Mr. Chairman, I don't have the resources. I'm just a lowly citizen who's just trying to make a little difference in good public policy. And the bottom line is what this bill does is tries to get folks to start disclosing things and talking about it in a public way so that we, the public, with you as policymakers, help with good privacy protections, accountability, and public scrutiny. So, Mr. Chairman, I just wanted to share some of those thoughts because the bill does hit a nerve to some extent.
Representative Cornish.
Just quickly, Mr. Chair, it's really nice if we could help Mr. Neumeister out on his quest for more public information, but that's not what we're here for. Every time somebody's got a complaint about the checks and balance system and data privacy, that we enable them to neuter law enforcement in their process of finding criminals. So, however much we'd like to help him, I don't think this is the right way. It's just his opinion that these people are evading the data privacy laws. It's not facts. So thank you.
Okay, we're going to take I'd like to get the rest of the public testimony in now. And Representative Rosenthal, if you could hold for 1 second, and then we'll recess, and then we'll take this up again at 4 o'clock. Anyone else from the audience? Yes, sir.
Greetings. Hello again, Chair Paymer, members of the committee. I just wanted to comment. A commentator mentioned something about the concern that we might become a police state. Again, we're in a police state. I am the embodiment here of our police state. I'm available for questions. And then this bill helps to rein in law enforcement, which is absolutely essential. The Founding Fathers did not create a government where we're supposed to be afraid of the police. And that's really what this is. I go out there, and you know what my stump is? I don't have any money. I don't have a campaign manager. My stump is I go grab a coffee at McDonald's and I talk to the person handing me my coffee, because I've done that. And so what I'm telling you once again here is that Mr. Cornish here represents the past. And some of the people like Representative Lesch, I'd like to give a shout out here too. He represents the future. And what we're trying to do in the state here, is to try to rein in law enforcement, because sunlight is the best disinfectant, and unless and until law enforcement wants to put this out on the table for the public, then why should we trust them? If they don't have anything to hide, put it out there for us to take a look at. What are you doing? And as far as Mr. Cornish, Rep. Cornish talking about we don't have facts.
Mr. Evanston, please don't address
there are facts as far as what people being violated their rights. They're in your jails and they're in your prisons, and they're walking into the government center every day. And then I would just make this final analysis once again. There are 21 white people on this committee deciding the laws for our state. So what we need to do is start getting representation by the people. And one thing, please finish. Our cell phones are dinging all day long, right? We are talking about electronic devices here. I have somebody tweets me, my phone rings. I got a pizza coming, my phone rings. Here's my point. What we need to do in this state is to return this government to the people, and here's how we can do it. You all figure it out on one side. Here's the issues, and then here's the pie chart with the $1 billion, and then we decide. We all do budgets. We have a checkbook. We know what our priorities are, our kids, our parents. We can figure this out better than you people. So I'm just going to make my final comment here. Text us when you guys have this on this side. Here's the 20 issues. Here's the $1 billion. Let us do our own pie chart, and let's use our technology. We'll feed it into a computer. We'll get an algorithm that'll kick out, and then you know what that'll be? It'll become we government, small w, big E, government of the people, for the people, by the people, not of the rich, for the rich, and by the rich. Thank you very much.
Testimony. Mr. Franklin, do you want to testify now or at 4 o'clock? It's up to you. We're going to recess in about a minute.
4 o'clock is fine, sir.
Okay. Representative Rosenthal. Anyone else? Representative Newberger.
Thank you. Mr. Chair, I just want to echo Representative Johnson's comment here. I do have concerns about this bill in the direction that it takes us. I'm very interested in our privacy. Several times during the year, I will sit down with my county sheriffs and speak to them and have lunch with them and discuss things with them. I can't ever recall doing that with anyone from the Bureau of Criminal Apprehension. The point I'm trying to make is, and to re-echo, is that sheriffs are elected, they're directly accountable to us, the voters. Bureau of Criminal Apprehension is not the case. And I just agree with Representative Johnson, and at this time I cannot support this.
Okay. Well, we'll take this bill up again, and Representative Cornish has made a motion that we have a roll call vote when we do vote on it. But we will, if you'll keep your papers in your folders, we will meet in room 300 at 4 o'clock. There's no further business before the committee. We are adjourned. Thank you. Recessed. I'm sorry. We are recessed.